Okay, we're live. Mark, call roll, please.
Representative Banks,
Here.
Representative Conrad,
Here.
Representative Heiner,
Here.
Representative Knapp,
Here.
Representative Larson,
Here.
Representative Lawley.
Unknown. Oh,
Represent-
okay, excused. No,
Representative Tarver. Representative Western. And Chairman Burkhart.
I'm here.
Thank you.
So we have two bills up today. The one House Joint Resolution wasn't noticed in time, so if you're here for that, we're not gonna take that bill up. We'll do it Monday. Please excuse my voice. I've got this crud that's going around. So first bill up for consideration is House Bill 35, Limitation on Environmental Rulemaking. And I will ask Representative Conrad to take us through that. You worked on the Regulatory Reduction Committee. You were kind of championing that. Can you do that?
I'd be glad to, Mr. Chairman. Thank you. In front of us is obviously House Bill 35.
Go down there, please.
Okay.
Director, you can join him if you wish. Representative Conrad, I hope I'm not putting you on the spot. Like I said, I thought you championed the concept and we've talked about it. And so I thought you could present it and then we'll get.
Chairman Burkhart, thank you for the opportunity. No, you're not at all, and I appreciate it again. We've worked collaboratively, I believe, and with good faith with the Department of Environmental Quality, and really appreciative of their input throughout this process. So in front of you is House Bill 35. What it does, as you can see from the short title, really limits environmental rulemaking. As we continue on, the most important part that I'd like to share with you is on page 3, line 7. Which is H, and really this is the gist of the bill. The council shall not promulgate any rules or regulations that impose standards or requirements that are more stringent than the federal law. In this case, rules or regulations that are applicable in this case to any federal program that the state maintains primacy over, unless the department identifies the need for rules or regulations that impose standards or requirements more stringent than federal law, rules, or regulations in its statement of principal reasons. Surprisingly, there are a few instances, which I think are admirable in this case, that we do need to have a little bit more stringent rules when the rules may not exist specifically within the federal law or rules. I'll give you just a few, and then I'll turn my time over to Director Parfit. There's specifically 3 that I have written down in cooperation with the department. The Ozone Green River Basin. There's 3 designations there. There's moderate, there's marginal, and there's serious. Specifically, the Green River Basin was a non-attainment. Allowing the Department of Environmental Quality to make this more stringent in case, go above and beyond or maybe below these restrictions, or more importantly, rules and regulations that the EPA has and federal government, we were able to turn that into serious instead of marginal, in which the oil and gas, and I'd ask anyone else who'd like to comment, which is more favorable, that allowed better economic activity, becoming more compliant in the regulations, and taking that into a positive aspect that allowed activity to proceed in a more expedient manner. The number 2 example I want to share with you is a phosphate plant. There's hydrogen fluoride that was being produced. The stock growers and others had a concern about the loss of weight in cattle based on the effects or potential impacts of hydrogen fluoride. In this case, the EPA does not have a standard, and the agricultural community had some concerns. So the Department of Environmental Quality were actually able to institute some rules and regulations or promulgate some expectations as it related to this case in terms of hydrogen fluoride. And there's another area around air quality rule. Last night, obviously, we heard a number of concerns about the number of challenges, or more importantly, regulations that we're going to see. But in this case, the EPA was challenged and now is less stringent than the state of Wyoming. For further explanation on that, Mr. Chairman, I'd like to turn that time over to Director Parfet. But I think this is a good rule. I believe that the department is in favor of this as well, but allows, again, the primacy to ensure that we're in requirements and, more importantly, meeting the expectations of not only the state law, but the federal law as well.
Yeah, thank you, Mr.
Director,
Chairman.
please proceed.
So just a real quick overview of the bill itself. As was mentioned, it came through the Regulatory Reduction Task Force back in November. And the bill really focuses on rules and regulations of the DEQ related to programs where the state has primacy or delegated authority from a federal agency, and that would either be the Environmental Protection Agency or the Department of Interior or Office of Surface Mines. So, and specifically, what we're looking at is where state rules may be more stringent than the federal rules. We follow an existing process when we do rulemaking, which includes creation of a statement of principal reasons. We bring that forward to an advisory board. There's a 30-day public comment period. After it goes through the appropriate advisory board, it goes to the Environmental Quality Council, and there's a 45-day comment period there as well. So we follow the process that's listed in the APA currently, but there are instances where we are more stringent, and it would do well, I think, for us to take a look back and see where there are issues or where the regulated entities are having concerns over an area where we're more stringent than the federal requirements. I won't go into any more examples. Representative Conrad did a nice job of giving a few examples of why it's valuable to go through this process and why it's valuable to have rules that in some instances are more stringent than the federal regulations. So what we also are charged with doing in this bill is that the agency would work with the regulated community, and the way we would do that is through the associations to identify areas where we're more stringent than the feds, and there's concern about that or an issue with that. And then we would prioritize those for rulemaking and further discussion with the advisory boards and the EQC. And then, if necessary, make any changes or at least further identify why the need for being more stringent than the federal requirements.
So, Director, I'm going to interrupt you there. So, while you would work with NGOs on this, I assume the department also work with an individual who may have an issue. Am I correct?
Mr. Chairman, that's correct. We currently do that now, so somebody can petition the agency to undertake rulemaking.
Okay. I just wanted to be clear for everyone that you aren't limiting it to NGOs.
So, Mr. Chairman,
Proceed.
yeah, for this bill, specifically in Section 2, line 21, it says that the DEQ shall consult with regulated stakeholders to identify a list of existing rules to be reviewed by the director. Mr. Chairman, that pretty much summarizes the bill, and stand for any questions or any further questions.
Questions for the director or Representative Conrad? Representative Larson.
Thank you, Mr. Chairman, Director Parfit. I just want to make sure that you're comfortable with this bill and it gives you enough flexibility to put into more stringent requirements if you have to.
Mr.
Director?
Chairman, Representative Larson, yes, and there was a lot of discussion through the Regulatory Reduction Task Force, and it had a variety of different versions. This is a version that we're comfortable that we can proceed with.
Any other questions? Okay, Representative, Director, thank you. With that, I'll open public comment. I see no other legislators in the room. Any other state agencies? Okay. Anybody from the public? And I see that we have no one online, correct? Okay. Mr. Detai, you know the drill.
Good morning, Mr. Chairman. Travis Detai with the Wyoming Mining Association. In support of the bill, and I would just really appreciate the work of the task force this summer and the work that the agency has done to get to this point. You know, we recognize from an industry side that there are certain situations where more stringent requirements are necessary. And I think what you got to understand is there's a reason for that. And the reason is to keep the federal government kind of off to the side so that we can do it here and stop with that interference. Director Parfit and his team, we've already had preliminary discussions to do that look back on some of those regulations that may need that look. So we are doing, we have a process in place with the agencies and from the mining industry. You know, we meet on a regular basis with our industry sectors and the regulators to identify these things, to talk about this. And we've been doing that for a long time. So, you know, we're supportive of the bill. It's a good little bill, and we would hope you would move it forward. Thank you, Mr. Chairman.
Thank you. Any questions for Mr. Detai and the Mining Association? Questions? Nope. Thank you.
Thank you, sir.
Anyone else from the public wish to speak on House Bill 35? One last chance. Okay, I'll close public testimony. Committee?
Move the bill.
Moved by Heiner. Seconded by Knapp. Any discussion? Oh, JT was second? Okay. Got that, Mark? Okay. Any discussion on the bill? Okay. Any amendments? It's a short bill. I'm not going to go through it page by page. Question being called. Mark, please call roll.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Heiner.
Aye.
Representative Knapp.
Aye.
Representative Larson.
Aye.
Representative Lawley.
I guess excused. Mark, we'll leave the vote open until we're done. We only have one more bill, but at the end of the bill, if she's not back, we'll just mark it excused.
Thank you. Representative Tarver.
Aye.
Representative Western. Chairman Burkhart.
Aye. Okay, so anybody, normally just assign it to Representative Conrad. He did a lot of work on it, was on the Regulatory Reduction Task Force, but anybody else really want to go to the mic? Okay, Representative Conrad, it's yours.
Thank you.
You're welcome. Okay, next bill for our consideration is, and that was a vote, by the way, on House Bill 135, limitation on environmental rulemaking. Next bill is House Bill 141, state land, oil and gas leases, operator requirements. Before we get into that, Representative, I did not get your Bill 145 read in time, so it won't be handled today. It'll be Monday, while I'm thinking of it. Same with Representative Larson's Joint Resolution 3. So in case either of you were thinking of doing it. So 141, proceed.
Thank you, Mr. Chairman. Members, I've got House Bill 141 in front of you, and I obviously ask for your favorable consideration. Before we actually kind of go through the bill, I want to provide a little bit of context here. You know, we've had a situation here in the state of Wyoming where environmental groups have been actively bidding on oil and gas leases for state minerals. And this bill ultimately poses the question of, is that problematic? And I believe so. We are an extractive industry state. We all know that. And at the end of the day, I think we want to ensure a process that ensures those operators and those businesses get to engage in that, you know, without outside forces influencing their business. And so what happened was some of these environmental groups were bidding on these leases, and they were bidding up the price above and beyond what it would have been if there were other operators bidding for those leases. And so I think a couple of different things at play here. One, I think it sends the wrong message, right? And two, of course, there's the financial implications that we are putting additional financial stress on some of those operators that they wouldn't have to incur otherwise, right? And certainly for no good reason or for the benefit of our, of citizens and taxpayers. And so that's kind of the story behind this. And what this bill ultimately does is ensures that only those, that our operators are involved in that bidding process are allowed to actually be awarded the lease. And obviously, some of those bidders are, big publicly traded companies with tons of money, but some of them are not. As a matter of fact, the person who brought this forward to me, the operator that did, I think they're a company of about 10 employees or so, 15. So, it's also some of our small mom and pop operators as well that are having to pay extra out of pocket to be awarded these leases. And that's exactly what ended up happening. So, Mr. Chairman, with your permission, is it okay if I just walk through the bill?
Please proceed.
Because you can see it's pretty short. Really just comes down to paragraph P on page 2. And we can obviously, I'm more than happy to read it through. Before issuing a lease of any state lands or state land school lands for oil and gas production under this article, the director, subject to criteria established by the board, shall review the highest bid offered by an applicant to determine if the applicant is a qualified oil and gas lease applicant in accordance with rules of the Board of Land Commissioners. I lost my spot here. Okay. If the highest bidder is not a qualified bidder, in this case, an environmental nonprofit, then the board shall consider the second highest bidder to determine whether that bidder is a qualified applicant, upon which the board may issue the lease if the applicant agrees to lease the lands for the highest amount bid before the disqualified applicant entered the lease auction. And so that kind of is the first part of this paragraph. Then we proceed to the second part, or for the amount that the second highest bidder bid, whichever is lower. Any applicant whose bid is rejected under the subsection because the applicant is not a qualified oil and gas lease applicant shall be subject to a civil penalty in the amount of the applicant's highest bid. The Attorney General may bring an action in a court of competent jurisdiction to recover the penalty specified in this subsection from the applicant. Obviously, we're giving the Attorney General authority, if they so choose, to take it to the next level. Obviously, we can go to page 3, section 2. Just talks about how the Board of Land Commissioners shall promulgate all rules necessary to implement this act, including the definition of a qualified bidder. Section 3, nothing in this act shall be construed to alter, amend, or impair any oil and gas leases for state lands or school state lands or lease assignment issued or made before the effective date of this act. And of course, there's the enactment date. So, committee members, that's the bill. There's multiple ways to go about this, and I consulted quite a bit with industry and with industry representatives. Kind of what's the best way to approach this. They kind of figured that this way of saying, okay, we look at all the bids, and then from there we kind of do reverse math to back into who they are and how much the amount is, and then going to the next highest qualified bidder. This is just certainly one option. I'm certainly open to alternatives. I think at the end of the day, our job is to solve problems. So whether it's this exact language or whether we want to go in a different direction, I'm certainly open to that. So, Mr. Chairman, committee members, if you have any questions, we'd be happy to answer them.
Questions for Representative Western? Questions? So Representative, then I'm starting on line 15. And that the start of the sentence on that line, any applicant, and then it goes on about the penalties and that. Is there an appeal process for this? Most of our statutes that have language like this have an appeal process. That the group, person, whatever, can appeal the decision.
Mr. Chairman, it would be the process that they already have on the books through the Board of Land Commissioners.
Okay. Other questions? No? Okay, thank you. Let's see, who's out there? I don't see any other legislators, so state agencies. And no one from the governor's office, so. Representative, you can come on back up here if you want, or stay there, your choice. Director, Deputy Director, you know the drill.
Thank you, Mr. Chairman. I'm Jennifer Scoggin. I'm the Director for the Office of State Lands and Investments. With me today is Deputy Director Jason Crowder. Thank you for the ability to appear before you today and comment on this bill. I think to start with, our biggest concern here is that it's not just operators that participate in our oil and gas leasing process. So one of the biggest challenges is going to be to define qualified oil and gas lease applicant as set forth in the bill, because we're going to need a definition that encompasses a lot of the complexities, such as, lessees that only hold the lease or some portion of it but don't produce. They hand out operating rights or lease rights and only retain royalty interests. There are those lessees that are speculating. Another operator will come and buy the lease from them. We have lessees that are securing larger acreage plays to package and sell to operators. We have lessees that secure a lease that's already in an existing oil and gas lease unit or a CA with another operator. So we'd want to be careful to not exclude proper applicants. And so I think that's going to be challenging. Another challenge we have is, where's the best place really to scrutinize this? Our current process, our definition for a qualified applicant, it's pretty low. It's essentially, and I'm paraphrasing, if you are an entity, a corporation, LLC, whatever, you must be properly registered with the Secretary of State. It doesn't really differentiate between, whether they're environmental groups or whatever else. And so we have folks, as I understand our process, check the box on the application and sort of self-certify that, and they get into the auction. Some of the issues that have been raised, I think, by operators, as Representative Western was talking about, and running up the bids and whatnot, perhaps it might be better to vet folks before they're allowed to get into the auction. So then that way that the people participating in the auction have met that definition, rather than doing it on the back end after folks have been bidding it up or allegedly bidding it up. I think another issue here is this isn't a huge problem that we've experienced in the agency. In my tenure here, we've had one instance in which an environmental group was the successful bidder. We were able to identify that based on the name of the entity. The board has rules that say that the board has the discretion to not issue a lease if it's not to the benefit of the beneficiaries. And in that case, we took the lease before the board, and we recommended that they not issue that lease because we knew that this was not an entity that was going to develop that lease. And the board complied with that, or took our recommendation. And but in that particular instance, there wasn't a second bidder to go to, but that's likely how we would have addressed it. Now, I can't say for sure how many times NGOs and environmental groups have participated in the bid process and bid it up, but they've done so lawfully based on our definition of a qualified applicant at this point. So then I would just say, I think it's important to remember, who are we doing this for? We're doing it for the trust beneficiaries, which are largely K through 12 education, and the institutional beneficiaries that we also look out for. Presumably, on the bidding issue, I understand where industry is coming from on this, but presumably they have done their homework and they have tried to figure out what the market is for these leases and determined how high their entity is willing to go on it. And so there is a market. They've figured out what that market is, and they've been willing to bid up to a certain amount, and that's what they've done. And either they have been the successful applicant or they have not. If it's an NGO that turns out to be the successful applicant, like I said, we would go down to the second highest bid. We're trying to obviously drive revenue for the trust beneficiaries, but we understand the frustration with not qualified applicants participating. So we are looking at other ways to address the issues that have been brought to our attention from environmental groups, such as, look, we'd really like to be able to do conservation in certain areas and take care of the surface. So assuming we get some more, we're successful in our requests for additional employees, we're trying to free up bandwidth to have a conservation leasing program to help protect the surface in those areas that are important. Haven't figured out what that looks like, but we're looking into it. Another thing that we are actually looking at to drive revenue in instances of oil and gas leasing is a sealed bid process, and we're actually implementing that in our March upcoming oil and gas lease auction, in which the direction will be, hey, give us your highest and best bid, and then we open those, they'll be confidential, and we'll see who the winner is. We think that that might drive some revenue rather than just, have an online competitive bid where there's only, $1 is bid because the successful applicants only paying $1 because nobody else is bidding. So with that, I would yield to Deputy Crowder for anything that I've left out. Deputy, do you want to?
Thank you, Director. Mr. Chairman, I think the Director did a great job of explaining the situation and the current process. One of the other things she hit on, and I can just expand a little bit, is what we currently do to protect the integrity of the surface. Obviously, these environmental type bids that come in are for a protection of a certain habitat type or the surface in some way. And we do stipulate our oil and gas leases for protection of specific habitat types. We work with our sister agencies to do that. So when oil and gas companies bid on a piece of property, they're doing it fully knowing what the restrictions are on use of the surface. The issue has become that sometimes those restrictions or the regulations that would imply those restrictions don't happen quick enough compared to when our oil and gas lease auction are, or possibly the environmental group have a greater sense of concern than our sister agencies do for that particular habitat type. So they're trying to get into the door and raise that issue, as the Director mentioned, that there is a concern there that our standard stipulation simply doesn't cover. And it's a good way to get our attention for that, for sure. As the Director mentioned, we need to know what the market is for that parcel, so we allow the auction to go forward, oftentimes knowing that there is some sensitive concern that a sister agency didn't identify, just to make sure that there is interest, there is a possibility for oil and gas development on that property before we go into it. And as she mentioned, we've been very successful in utilizing our existing rules when those entities become the winning bidder, knowing that they're not there to develop oil and gas, and we can pull that back and concentrate with the second bidder, or if there is no bidder, concentrate on the conservation leasing idea.
Questions for Department of State Lands? Any questions? Yes, Representative Heiner.
Thank you, Mr. Chairman. Director Scoggin, I think you understand what we're trying to accomplish here, or what the bringers of this bill are trying to accomplish. Is this something that can be handled through rulemaking in your organization without needing to go through this statute?
Director?
Mr. Chairman, Representative Heiner, I believe so. I believe that we can work on crafting some of our definitions. Also, as I mentioned, I think our process is our process now, but it may be an idea, if you will, to address some of these things by, like I said, vetting these applicants on the front end of things rather than having them go through clear to the end. But the thing with the rulemaking process is it allows a lot of public comment. And so we would want to work with industry to find a way so that this works for everybody. But I think that that's the best place to start, is rulemaking. And as I mentioned, some of the board's existing rules, we believe already handle this, but there's always room for clarification.
Follow-up?
Thank you, Director. Appreciate that. Would you commit to doing that if this did not move forward?
Mr.
Director.
Chairman, Mr. Chairman, Representative Heiner. Yes, in fact, we were just talking with Mr. Obermuller in the back saying, hey, maybe we should take a step back and work through this together during the interim and come up with something that works a little bit better for everybody. But yes, we would commit to doing that.
Okay. Other questions? Representative Western.
Thank you, Mr. Chairman. It's Director Scoggins, and I think Representative Heiner asked a good question and raises a good point. But if that's the case, why haven't you done so already when this has been a repeated incidence and occurrence within the bidding process?
Director?
Mr. Chairman, Representative Western, I think that's where we have a little bit of a disagreement. This hasn't been a big issue for us. And in the one instance where we did have a successful bidder that was an NGO, we were able to take care of it with our existing rules. Now, yes, we are aware that in some instances, NGOs have been in the bidding process, but it's a blind bid. Everything's confidential. Nobody knows who they're bidding against. So for all they know, they could be bidding against their competitors. So, and as I mentioned in my opening remarks, is presumably everybody has done their homework there's a market that's being created, and people know what they're willing to spend in that market and stop when they've reached that point. And then if there is an NGO or that happens to be the winning applicant, as I mentioned, we wouldn't issue the lease to them. If we know that's the case, we would go to the second highest bid, which is, I believe, the way that this draft bill addresses it.
Mr. Chairman, follow-up. So if that's the case, because it's a sealed bid, you have no way of knowing how many NGOs have been involved in this bidding process and for how long this has been going on. Is that correct? Director?
Mr. Chairman, Representative Western, I don't think that's the case. I think that we know that it's going on, but we don't always know to the extent. We hear from the NGOs that they're bidding and that they have been doing that to address some of their concerns. But as I mentioned, when it comes to actually awarding the lease, it has not been an issue for us.
Follow-up?
Mr. Chairman, thank you. So it sounds like you don't know for how long and to what extent these NGOs have actually, like, you can say for sure that they are participating in this many bids, they're driving up the price by X amount of percent. It sounds like you're unaware at this point.
Director?
Mr. Chairman, Representative Western, I think that's an unfair characterization. What I'm saying is, when it comes out in the wash at the end of the process, it hasn't been a tremendous issue for us. We are, and maybe Jason, you have some statistics that I don't have. But again, as we've become more and more aware that the oil and gas industry is concerned about this, obviously we have been talking to the NGOs. I know Jason has been talking to the NGOs, and when we find out they're doing it, we slap their hands and say, this isn't the process to do that. Let's try to work through the issues that you're having to address those issues.
Follow-up? Mr. Chairman, thank you. Follow-up. So some of the operators I've spoken to that have been and know they've been involved in these auctions with some of these NGOs, they've had to pay more. And you talk about kind of the true market price. If you have artificial participants in the market, you're creating an artificial market, an artificially high price, right? I mean, some of them may very well not intend to actually pay for that bid, and they're just trying to drive up the price. Obviously, we don't know that for sure, but it is a possibility. So at this point, I mean, how can we prevent that without stuff like this on the books?
Director?
Mr. Chairman, Representative Western, as I mentioned, I think that there's a couple of different ways to come at this. The draft bill is one of those ways. I also think that there's a possibility that we flip it on its head, meaning that we vet the participants based on whatever the definition of a qualified applicant is going to be on the front end. So they're not getting into that auction unless we know for certain that they are part of the oil and gas industry and a qualified applicant to participate. Then we don't have, presumably we wouldn't have that bidding it up, creating an artificial market.
One last follow, Mr. Chairman.
Follow-up? Go ahead.
So I certainly appreciate, the definition. There's a lot of complexity there. People who, have a business model of just leasing and then subleasing. I think that's a legitimate concern. If you look on page 3, section 2, do you think that gives you the flexibility to implement those kind of definitions and making sure we're not excluding any legitimate oil and gas businesses in this process?
Mr. Chairman, Representative Western, I'm sorry, what was your
Proceed.
reference? Section 2, is that what you're referencing?
Mr. Chairman, Director, yes, that's correct. So just section 2, because again, one of your concerns was obviously it's more than just any oil and gas company. There's lots of quote-unquote qualified participants. And I think that's a reasonable concern, and I fully agree. Do you think section 2 and then the language there gives you guys that flexibility to make sure that we are capturing who we're supposed to and excluding the people that we are intending to?
Director?
Mr. Chairman, Representative Western, yes, I mean, it allows the board to promulgate rules, but the board has that authority now to promulgate rules related to this. And certainly, we would like the opportunity to work with industry and all. And as I mentioned, it's in my remarks, the types of folks that we don't want to exclude. We want to make sure that everybody has input. And yes, I believe that the board can promulgate rules, but as I mentioned, I think they have that ability now. And as I mentioned, the board may wish to maybe have discretion to come at this a different way, as I mentioned, like maybe vetting beforehand rather than on the back end in order to address the concerns about the artificial market that you believe is being created. So what I'm saying is that's why we were thinking maybe we can take a step back and see if it's possible to craft something in the rules, maybe tweak processes that we have in line with vendors and things like that, that may be able to address this without having to have a new statute.
Okay, other questions? Questions? No? Okay, so, Director, about how many, I'll make this a little broader. How many sections currently in the state do you have under lease, do you think? And I don't need an exact number for oil and gas leases. I mean, obviously, some of the state lands aren't gonna be useful for that. There's no oil and gas under them, so. Deputy Director?
Yeah.
Okay, we'll put you on the spot.
Thank you, Mr. Chairman, appreciate that. Currently, it runs between 1,500 and 1,600 active oil and gas leases across the state. That's 3.9 million total subsurface acres that those leases could be on. Also, another important statistic, only 27% of our leases ever reach production. So that part of that 1,500 are speculating leases that are within their 5-year primary term, or they're producing leases, but it's a relatively low number compared to the amount of leases that we actually let out ever reach production.
Okay. So I guess we were lucky in some areas and unlucky in others when we were given the school sections and the other state sections. Okay. So, no, never mind. I had another question, but it's not important. Anyone else? Any other questions? Okay, thank you, Director, Deputy Director. Hang with us in case we have questions. Okay. Other state agencies? Director Kropatch? Nope. Okay. Oh, Director Scoggins or Deputy Director, either one, could you come back up? I did remember my question. I apologize. Correct me if thank you. Correct me if I'm wrong, but part of your mission is to get the most value and the highest return from those state lands. Am I correct?
Mr. Chairman, that is correct. We have a fiduciary duty to the trust beneficiaries to look out for their interests and to generate revenue largely for K through 12 education. That's the biggest, largest beneficiary. And that's why being able to offer leasing opportunities and driving revenue is obviously important to us, but we also understand industry's concerns.
Okay, so just bear with me, please, a little bit. So if you had two different resources on a section, say sand and gravel was one, oil was the other, and they were not mutually developable, would you go with the highest value one? If say sand and gravel quarry would generate more money for the state, do they get a priority?
Mr. Chairman, I hate to speculate. The board
Okay.
obviously has the discretion to determine what activity would be in the best interest of the trust beneficiaries, and it would depend upon a lot of the facts. But I will say that with respect to revenue generation for 2023, I believe 88% of the 230 million that we generated for the trust beneficiaries was due to oil and gas operations.
Thank you. I'll let you go sit down now. Thank you for your patience. So any other state agencies? Okay. With that, anyone else? Mr. Obermuller, you're already on your way up here.
Good morning, Mr. Chairman. Members of the committee, Pete Obermuller, Petroleum Association of Wyoming. Mr. Chairman, I think it's important that we start out by just acknowledging the absolute marvel that is Representative Banks' jacket today. That is just, that is amazing. I love that.
Mr. Obermuller, is that a little sign of jealousy?
I've just been staring at it all morning thinking, why don't I have that? That's amazing. Sorry, Mr. Chairman, couldn't help myself.
I understand. Proceed.
Thanks for taking up this bill. Really appreciate Representative Western bringing the bill. And Mr. Chairman, I'm going to ask you to pass this bill. I think my friends at OSLI do amazing work. They do amazing work on behalf of the beneficiaries. But to be frank, Mr. Chairman, I think they have it wrong on this bill. So let me talk a little bit about it. First of all, the bill is they're talking about how it hasn't happened very much and all that. That's all fine. That's okay. And I understand that argument. If it doesn't happen very much, why do we set policy? What happened earlier this year, I believe, was a test run. It was a trial balloon to see what we do about this. And having a bill like this sets up a deterrence that ensures that it won't happen again. And that's important because for a number of reasons, which I'll get to, but the one I'm going to start with is that we have already done this for our agriculture community. A very notorious anti-grazing NGO tried to bid on grazing leases a few years ago. You know who stepped in to correct that? This body. And I think our oil and gas industry needs that same protection. So let me talk about a few of the things that the director talked about. First of all, and Representative Weston alluded to this, they started talking about complicated definitions. It's partly why it's a little bit different from, I wish that we could just copy and paste the agriculture, but it's a lot easier to define what that is. So that's all fine. But Mr. Chairman, status quo is that. So right now, anybody could come in. Representative Conrad could come in and say, you know, a Conrad NGO and bid, and they don't know anything about him. He bids and he wins. And then they go through a process right now of figuring out whether he's legitimate or not legitimate as best they can, and they issue the bid. That's okay. What the bill does, it doesn't change that process. It allows that process to go forward and they use the process that they currently use to make that determination. Now, maybe they make a mistake. They just don't know who it is, and it gets issued to somebody who doesn't intend to drill. But that's a risk we're willing to take precisely for the reasons you all are talking about the various entities that do bid. It's the difference between exploration and production. There's lots of companies that put together packages and are exploring and all of that, and that's all fine. We're okay with a little bit of that ambiguity in that definition. So that's why it's intentional that we didn't try to define it here. But it's also been intentional that OSLI has not tried to define it either in current rules. So I don't think, like the complicated definition part, I don't think is really an impediment. The timing, whether it's before or after, there's nothing to prevent the agency from currently or under this bill, as Representative Western pointed out on Section 2, that would allow them to promulgate rules that allow them to vet at the beginning too, and that would be fine with me. Vet at the beginning, vet at the end, do all that vetting. That's totally fine. They can do it now. They can do it under this bill. But here's why I think we need the bill. And you heard it from the testimony itself, from the office, is that they're starting from a philosophy that it is totally okay for people who never intend to drill and in fact are bidding to stop drilling, to bid up my members because my members don't know that it's them who are bidding. And so they're saying that somehow creates like the true market, that an unqualified bidder has bid up one of my members, and that creates the true market because we didn't know that they were unqualified. I just fundamentally reject that. And so to Representative Heiner's question about will they commit to working on a rule, I absolutely believe they'll commit to working on a rule because they're upstanding people. But they're starting from the point that it's okay that unqualified bidders bid because that will earn more money for the trust beneficiaries. And I fundamentally reject that. And I'm asking you to reject that too. And that's why I think the bill needs to move forward.
Any questions for Mr. Obermuller? Any questions? I guess you get off easy.
Thank you, Mr. Chairman.
Okay. Anyone else in the room? We have no one online. Anyone else one last time? Okay, I'll close public testimony. Committee? Move the bill. Moved by Conrad, seconded by Banks. Discussion on the bill? Question being called. Mark, please take the roll. We're voting on House Bill 141, State Land Oil and Gas Lease Operator Requirement.
Aye. Representative Conrad,
Aye.
Representative Heiner,
Excused, but I think he left to vote.
Representative Knapp. Aye. Representative Larson,
Aye.
Representative Lawley,
Excused with no vote.
Representative Tarver. Aye. Representative Western. Aye. Chairman Burkhart.
Aye. So, okay,
House Bill 141 do pass.
okay. So with that, the votes are closed because we're done. Believe me, you don't want to be Representative Lawley this morning. There was no notice to the chairman that she would not be here. Okay, so, okay, any other business? We're adjourned.